On October 20th, 2021, the U.S. Department of Homeland Security, United States Citizenship and Immigration Services, or USCIS, released Volume 3, Part B of the USCIS Policy Manual for T non-immigrant visas, also known as T visas. The USCIS Policy Manual is the agent's repository for USCIS's immigration policy. The manual contains separate volumes for different areas of immigration benefits. This is the first version of the T visa section of the policy manual and supersedes prior adjudicators' field manual and USCIS issued policy memos. You can find the entire policy manual on the USCIS website. This video will focus on the new T visa sections and some notable highlights. If you are unfamiliar with these terms or the T visa process, please pause the video and register for our T visa Part 1 course, which is linked in the description below. The T visa course discusses the basics of filing a T visa. Additionally, for a more thorough review of the highlights for the T visa section of the policy manual, check out our policy manual advisory, which is linked below in the description. Before diving into the substantive portions of the manual, there are some overall considerations and observations we'd like to provide. First, the manual provides guidance on how to approach T visas, but is distinct from the T visa regulations. The manual interprets existing regulations. As a reminder, the current regulations are not finalized and still subject to revision. As a result, the manual may be updated to reflect changes in the regulations. As of January 2022, there is no public timeline on when the regulations will be finalized. For your convenience, we have provided the links below to the regulations and the unified agenda. Finally, the appendix of the manual provides substantive, supplementary information, including a case law reference table, which clarifies several concepts. The footnotes also provide additional context and analysis. Both the appendix and the footnotes should be read along with the body of the text for a richer understanding of how USCIS may interpret a T visa case. Now let's dive in. The first highlight we'd like to share is that Chapter 2 of the T visa section provides new and clarifying definitions for severe form of trafficking. While some of these definitions have existed in the Trafficking Victims Protection Act, the definitions are newer to immigration guidance. The new definitions include harboring, serious harm, slavery, and peonage. The policy manual also provides new clarification on what actions by a perpetrator constitute a threat for purposes of legal coercion. For these definitions, there are several case law examples in the appendix. The second highlight is that in the policy manual, USCIS provides lengthy clarifications on how to establish physical presence on account of trafficking. The regulations provide 5 different ways to establish physical presence. In this manual, USCIS clarifies the interpretations of the regulations, including what law enforcement agency liberation or involvement means for purpose of physical presence, confirms that the T visa does not need to be filed within a certain time frame, and explicitly states that an individual's personal or professional milestones do not prevent the establishment of physical presence. Additionally, the policy manual provides thorough explanations on what type of evidence is necessary to demonstrate physical presence. Reviewing both the eligibility requirements chapter and the evidence chapter for physical presence will provide additional important information about how to establish physical presence. For example, in the evidence chapter, the manual states that a victim who is liberated from a trafficking situation is not exempt from showing their current presence is on account of trafficking, which could be interpreted different from how the eligibility chapter suggests. Third, the policy manual now clarifies that the age-based exemption to the law enforcement cooperation requirement applies based on the victim's age at the time of victimization. This has been a long-awaited clarification for practitioners. The fourth highlight we'd like to showcase is the additional information the manual provides on extension of status for T visa holders. Also, USCIS has now provided guidance that T1 applicants can use their I-94 approval notices with their I-485 adjustment applications as evidence of employment for 24 months from the expiration of their T visa. One final highlight is an important update to the Waiver of Inadmissibility section of the manual. In Volume 9, Part O, USCIS provides an in-depth explanation of which waivers of inadmissibility are available to T visa applicants and how those waivers apply. This section provides an easy-to-read table on what waivers are available for many inadmissibility grounds and the legal authority to waive those grounds. We encourage practitioners to take the time to read through the latest updates in the policy manual as well as the existing statutes and regulations. If you have any questions on the updates to the policy manual or are a legal practitioner in need of case support, contact us for technical assistance or join us on our weekly legal working group call. The link for technical assistance requests and our call are in the description below.